Also, Your Honor, I would like to ask that all witnesses be constructively sworn.
There will be.
I would also like to confirm that time will be stopped for all objections.
It will.
With that, my co-counsel has a substantive matter to address, Your Honor.
All right, before we get to that, are there any housekeeping measures from the plaintiff?
Not at this time, Your Honor, although we do also have a notice of appearance in a binder for you. May I approach?
What's in the binder?
We have the stipulations, the evidence, as well as the rules of competition.
All of those are already in your binder that you passed up, right?
I don't believe we have the rules of the competition in there, Your Honor, but everything else that the plaintiff's counsel has referred to is in there.
I guess I'll take the whole binder. I would tell you to take it apart in the future cases if they just have passed something up and show it to you.
And Your Honor, at this time we have a few substantive motions as well.
All right, we will hear from defense first.
Yes, Your Honor. To begin with a brief background on today's case, it was on August 18th, 2013 that the plaintiff's husband passed away in a plane crash on the defendant's property belonging to Mr. Thomas Thompson. On the way from Kansas City to Dallas here in Lone Star, about 10 miles outside of the ranch, the plaintiff's husband's plane, it ran out of fuel, causing him to make the emergency landing. He went to the defendant's property. That's where he landed and the plane crashed. Today we will show evidence that it was not the negligence of Mr. Thompson that caused that crash, but rather the negligence of the decedent. Our motion in limine today is in regards to testimony about Mr. Thompson's alleged negligence. In the complaint, the plaintiff set out a very specific allegation for negligence, specifically that Mr. Thompson failed to adequately and properly maintain the lighting system on his runway. Today, however, we do anticipate that they will present evidence on an additional allegation of negligence, that Mr. Thompson was also negligent in failing to notify either the Federal Aviation Administration, which we will refer to as the FAA, and failing to notify air traffic control. However, Your Honor, they did not list this in their complaint. Therefore, it is inadmissible in today's trial. We ask for an instruction regarding that at this time.
Response?
Yes, Your Honor. If I may direct Your Honor's attention to the plaintiff's complaint, on the second page of that complaint is the specific allegation of negligence. Specifically, the plaintiff has alleged that the defendant was negligent in properly and adequately maintaining the runway on his property. In today's case, that allegation of improper maintenance includes the allegation that he should have notified a third party, specifically the FAA or an air traffic controller. That allegation is incorporated within the maintenance allegation that was raised in the complaint. Furthermore, the purpose of including all allegations in the complaint is to avoid blindsiding opposing counsel with an additional allegation.
I understand. Is this a notice jurisdiction?
No, Your Honor.
Yes, Your Honor.
Okay, well, since it's a notice jurisdiction, I'm going to overrule your motion.
Thank you, Your Honor.
Yes, Your Honor. The plaintiff has two substantive matters we'd like to bring to the court's
Okay. Are there
attention.
any more from the defense?
No, we're done, Your Honor. Thank you.
Your Honor, our first motion involves Exhibit 1, which can be found in the trial materials you have before you. Exhibit 1 is an expert report that was prepared by the National Transportation Safety Board and details that organization's investigation into this crash. That report gives opinions and provides conclusions as to the cause of this crash, many of which involve Zeke Fortenberry. In the way that this report gives conclusions and opinions as to the cause of the crash, it requires that the defense be able to lay foundation under Rule 702 about the qualifications of the author of this report, as well as the methods and principles that they used in making those conclusions and the facts and data they used in making those conclusions. Today, we do not anticipate the defense to call the author of this report to testify. Therefore, they will be unable to lay the proper foundation for the opinions in this to be admissible. And furthermore, the plaintiff will be prevented because they're not calling the author of cross-examining that witness as to the reliability and credibility of the conclusions in that document. Because
is this a treatise? Considered a treatise under the rules? Is this some document that people relied on in this case, an expert relied on in this case? How would this be coming up in the trial today?
Your Honor, experts have relied on it in this case. We do anticipate that that the defense will try to enter that document in its entirety here
Through
today.
an expert today?
Yes, Your Honor.
And the expert relied upon this document and they're forming a conclusion?
Yes, Your Honor.
Okay, and do you intend to offer this into evidence today or just testify generally about this document through your expert?
I do intend to offer it into evidence today, Your Honor. I would just like to point out, however, that plaintiff's counsel has stipulated to this document. If you look in the substantive matters section of your stipulations in stipulation 4, they admitted to its admissibility under Rule 803-8. Furthermore, Your Honor, it's not an expert report. It's a collection of conclusions of a public body, the NTSB.
Oh, about this case. So its conclusions are about what happened in this situation?
Yes,
Okay,
Your
I
Honor, the
understand.
NTSB investigated this crash, and so plaintiff's counsel stipulated to it under 803-8.
Okay, and you're saying that just because it's admissible under 803, under hearsay, that doesn't mean it's admissible for improper opinions because we can't lay foundation as to the expertise of the author?
Yes, Your Honor. Although we stipulated under 803-8 that this is not hearsay, we have not waived any other objection to it, and because the defense will not be able to lay the foundation under Rule 702, this document should be inadmissible here
Does
today.
the document contain any background about the author, anything in there that says where the author went to school, anything like that?
Your Honor, it's not about the author, it's the fact that this is the public body, the NTSB, that investigated this crash. Now, it's a public body, so that means that it would be admissible under 803-3.
I understand that, but what's your response to the Rule 702 objection? How is this not an improper opinion, or how is there not going to be enough foundation, or how will there be enough foundation to make this a proper opinion?
Well, Your Honor, the expert can testify as to the methods used in the report, the methods that the expert then relied on to come to her own conclusions. Furthermore, Your Honor, the fact that it was conducted by a government entity has a presumption of reliance. You know, we can rely on the people in working for the NTSB, and the expert will be able to talk about that as to how he came to his conclusions.
Okay, what I'm going to do is I'm going to hold this in abeyance, but I do ask you to bring it to the court's attention when you plan to use this document. And I also would urge you to lay some foundation about that organization, what they relied upon, and why they would be able to give those types of opinions. And we'll address it at that time.
Yes,
Yes,
Your Honor.
Your Honor, just to confirm, we're free to re-raise the objection to this document when it's entered.
Yes, and I ask that no one reference this document until you bring it to the court's attention so we can address this motion again.
Yes, Your Honor, thank you. Our second motion involves the claim of negligence that has been brought today by the plaintiff. Based on the pleadings and discovery in this case, we anticipate the defendant to contest several elements of the negligence claim. Specifically, we anticipate the defendant will contest whether a duty existed. Courts have consistently held that the determination of whether a duty exists is solely a question of law that can only be answered by the judge. Given that this case has proceeded to this point in litigation on the eve of impaneling a jury to decide the questions of fact, it's clear that the issue of whether a duty exists has been ruled upon in favor of the plaintiff. We would ask that the defense be limited from presenting testimony today through their witnesses that contests whether a duty actually existed. We have no problem with information as to what duty existed being presented, as it's necessary to frame what actually was breached. However, their defense witnesses should be prohibited from contesting whether a duty existed.
And why is duty a matter of law in this jurisdiction? Is there a case that you're basing that off of? What are you basing that on?
Yes, Your Honor, if I may approach with a case that was recently decided by the South Carolina
Yes.
Supreme Court.
And have you shown this case to opposing counsel?
Yes, Your Honor.
Okay.
I'm going to be referring to this paragraph.
One moment. All right, does the defense have a response to this motion?
Yes, Your Honor. In response to that, we would like to point out that this case is from outside of the Lone Star jurisdiction, that it is from the state of South Carolina. This is a slip opinion, Your Honor. It's not precedent in addition to being outside of the jurisdiction. And additionally, going into what was argued earlier regarding duty, Your Honor, we admit that there was a duty to the general public. However, it still requires that the jury make opinions on the fact, that they reach a decision on the facts to determine whether the duty extended to Alex Bell specifically
duty, the extent of duty and the scope of duty is just a matter for the judge to determine and not the jury?
Yes, Your Honor, as that case confirms, courts have consistently held that the existence of a duty is a prerequisite for proceeding to trial, and that's a question that can only be answered by the judge. And because we have proceeded to this point in the case, it's clear that that issue has already been ruled upon.
I'm gonna deny that motion.
All right. Yes, Your Honor, and with that, the plaintiff is ready to proceed.
Defense is ready to proceed as well.
All right, plaintiff, opening statement.
Yes, Your Honor. May it please the court? On August 18th of 2013, at 11:22 p.m., an air traffic controller's calm night is interrupted. It's interrupted by a distressed call, a call from pilot Zeke Fortenberry. Now, Zeke Fortenberry needs to make an emergency landing, and he needs to make that landing right now. Together, they find a runway with lights that give Zeke Fortenberry one shot at landing safely, and a runway with lights that gives him one shot at making it home safe to his wife, Madeline. Today, you will learn that those lights didn't work, and you will learn why. Now, at the end of today's case, you will learn that it was Thomas Thompson's actions that turned Zeke Fortenberry's one shot at safety, his one chance to make it home to his wife, into nothing more than a shot in the dark. I'm Claire Hollingsworth, and I, along with my co-counsel, Colin Spangler, represent the plaintiff, Madeline Fortenberry. Madeline could never have known that on that summer day, her life would be forever changed, that the last time she talked with Zeke would be before he took off, that every plan they'd ever made would never happen. When Zeke began his flight from Missouri to Lone Star, he had no idea that he would have engine failure, that he would have to make an emergency landing. And when he called air traffic controller Alex Bell, when he talked to Alex Bell and they found a runway, a private runway with lights where he could land, he learned that these lights were called a pilot-activated lighting system, and they could be turned on by the pilot from the plane. By clicking his microphone a certain number of times, a radio receiver on the ground would hear the clicks and turn on the lights. So Zeke began to click, and he began to click over and over and over again. And he was circling South Fork Ranch, losing altitude and losing speed. And he continued to click. But there was something that Zeke didn't know, something that only the defendant, Thomas Thompson, knew, that those lights didn't work. That no matter how many times Zeke Fortenberry tried to turn them on, those lights were never coming on. Members of the jury, today you must answer two questions. You must decide if Thomas Thompson was negligent and what role that negligence played in the death of Zeke Fortenberry. Now, to answer these questions, you need to understand what negligence is. After today's trial, the judge will come to you and she will explain what negligence is. And she will tell you that negligence is the failure to use ordinary care. So today we must prove to you by preponderance of the evidence that it was Thomas Thompson's negligence that caused the death of Zeke Fortenberry. To help you answer these questions, to help you know if Mr. Thompson was negligent, we're going to bring you two witnesses. We're going to bring you Alex Bell. Alex Bell was the air traffic controller that spoke to Mr. Fortenberry during his last moments. Alex Bell will tell you that while Zeke was clicking over and over and over again, nothing was happening. Alex Bell will tell you that those lights were important because it was an unfamiliar runway, because it was the middle of the night, and because Zeke was in an emergency situation. Alex Bell will tell you that those lights never came on. Additionally, we'll bring you Sam Williams. Now, Sam Williams is a mechanical engineer with expertise in accident reconstruction. Mr. Williams will be able to tell you everything about this PAL system, this pilot-activated lighting system. He'll tell you that Mr. Thompson, the defendant, used federal funding to build this system, and that with that funding came some rules. Rules about how to maintain these lights. Rules about what to do if those lights don't work. Now, Mr. Williams will be able to tell you exactly what was wrong with those lights. that the radio receiver that hears the clicks from the pilot and turns on the lights wasn't working. And Mr. Williams will tell you that that should have been fixed, should have been repaired before Zeke Fortenberry tried to turn those lights on. That on August 10th, when the defendant knew that there was something wrong with those lights, he could have and should have repaired them before August 18th. Now, members of the jury, we anticipate that the defense will call 2 witnesses. We anticipate that they will call Kim Bates. Now, Kim Bates is an aeronautical engineer. She can tell you everything you need to know about planes. But unfortunately, she won't be able to tell you anything about this pilot-activated lighting system. She has no experience in working with PAL systems. And additionally, she never even went to look at this PAL system. She won't be able to tell you what was wrong with it. We also anticipate that the defense will call Thomas Thompson. Now, Thomas Thompson may come up here and he may tell you that he did something when he knew that those lights didn't work. But members of the jury, do you know what he did? You'll find out that he sent one email to his employee that didn't even say to fix the lights. Today, when you're listening to all the evidence and you hear all the testimony, I want you to remember 3 things. That Mr. Thompson failed to shoulder the responsibility. That Mr. Thompson failed to obtain the repairs. And that Mr. Thompson failed to spread the word. So let's go through those things a little bit more. Now, we've already heard that Mr. Thompson accepted federal funding for those lights, which in turn means he accepted responsibility to follow the rules that he agreed to when he accepted that funding. So today you'll hear that when it came time for Mr. Thompson to shoulder that responsibility, when he learned that those lights weren't working, he failed to do so. Now, you'll also learn that Mr. Thompson failed to obtain those repairs, that he didn't call anyone to come fix the lights, that he didn't go look at the lights himself. He did nothing to obtain these repairs but send one email. And finally, members of the jury, you will hear that when Mr. Thompson knew that those lights weren't working, he didn't call anyone. He failed to spread the word to anyone that those lights weren't working. He didn't call air traffic control like a reasonable person would to let them know, don't send pilots in emergency situations to my runway because these lights don't work. Mr. Thompson failed to spread the word. Members of the jury, at the end of today's case, when you remember those 3 things, when you see that Mr. Thompson did fail to shoulder that responsibility, that he did fail to obtain those repairs, and that he did fail to spread the word, you will see that it was those actions, the defendant's actions, that turned Mr. Fortenberry's one shot at safety, his one shot at making it home safe to his wife, into nothing more than a shot in the dark. At the end of today's case, find Mr. Thompson liable. Thank you.
May it please the court. His fate was sealed. When Zeke Fortenberry sealed that gas cap in Kansas City, he sealed his own fate. Today, members of the jury, you'll learn a lot about airplanes, PAL systems, and the FAA. But the most important thing you'll learn is that fueling a plane is nothing like fueling a car. You can't just fill up the tank and go. Rather, you are required to make a precise calculation, calculating exactly how much fuel you need to get from point A to point B and have enough fuel to fly around for an additional 45 minutes. You'll see that is required by the FAA. But you'll also learn that Zeke Fortenberry didn't make the right calculations. He made mistakes. And unfortunately, that caused his plane to run out of fuel 10 miles outside of South Fork Ranch, right here in Lone Star. That caused him to have to make an emergency landing. And that led to the crash on the ranch of the defendant, Thomas Thompson. we also expect you to learn that nothing Mr. Thompson did or didn't do in August of 2013 could have changed that. Mr. Fortenberry's plane was doomed from the start, and when he sealed that gas cap in Kansas City, he sealed his own fate. I am Leanna McMiniman, and I, along with my co-counsel, Alexa Kleska, represent the defendant, Thomas Thompson, in today's case. Now, while we're here advocating for Mr. Thompson, while we're here in his defense, there is one thing that brings all of us here. Unfortunately, that is the death of Zeke Fortenberry. It goes without saying that his death was untimely, it was tragic, and we all have sympathy for the Fortenberry family in their time of loss. But in today's courtroom, members of the jury, each and every one of you are required to put aside those feelings, as natural as they may be, and focus on the facts and the law. And when you do that, you'll see Thomas Thompson is not liable in today's case. Now, like I said earlier, you're going to hear a lot about PAL systems and the FAA today, but what are those things? Well, the plaintiff did touch on that a little bit in their opening statement. PAL systems, it's a pilot-activated lighting system that allows any pilot flying a plane over an airstrip that has installed this device to click their microphone and turn on the runway lights below them. As simple as that. Now, the FAA, or the Federal Aviation Administration, that is a government agency that sets out rules and regulations for pilots, public airports, and even private airstrips like the one owned by Mr. Thompson out on South Fork Ranch. You'll see that those rules and regulations create responsibilities, and that the FAA had responsibilities for both Thomas Thompson and Zeke Fortenberry in August of 2013. Responsibilities that will become so clearly important to your decision by the end of today's case. Now, the FAA set out two responsibilities for Mr. Thompson, and you'll get to see those. You don't just have to take my word for it, we'll show it to you in something called a circular. It's just a document, and it says that the rules, they apply to Mr. Thompson's airway because he did accept a federal grant from the government to build that airstrip. And then it states that those two rules are, 1, to take reasonably prudent practices in maintaining the airstrip, and 2, to take reasonable steps in fixing the PAL system whenever it may become broken. Fairly clear, and not something that we're going to hide or gloss over today. No, we admit that those are Mr. Thompson's responsibilities. In fact, we'll call him to the stand today, and he'll tell you that himself. And to take it one step further, members of the jury, the plaintiffs have said time and time again in their statement that the lights were broken. Well, we admit that. We'll go ahead and put it out there right now. On August 18th, 2013, the PAL system remained broken. But you'll see through evidence and testimony that while it's unfortunate those lights weren't working, it's not unreasonable. And Mr. Thompson was required to act reasonably in fixing those lights. Now, how will you know? What will you see to show you that he acted within his responsibilities? Well, first off, you need to know when he was first notified that the lights might be broken. You'll see that that was on August 10th, 2013. A friend of Mr. Thompson had flown over to South Fork Ranch, and they were trying to use the PAL system. They clicked their microphone, and the lights didn't come on. Someone else had to go down there and turn them on by hand. That's when Mr. Thompson learned that the lights might not be working. But what you should take note of as well is not just when he was notified, but what he did in response to that. Mr. Thompson sent an email to his ranch manager, Mr. Barrett. You'll learn that Mr. Barrett is his right-hand man, his go-to guy. He's the ranch manager. He fixed things on the property. That's why Mr. Thompson emailed him. And you should also note, members of the jury, when that email was sent, which you'll see today. You'll see the email yourselves. It wasn't sent the next morning, the next afternoon, or the day after that. It was sent that same night. We expect you'll find that was reasonable. And now the plaintiffs, they might try and tell you that the email was insufficient. They might say that 8 days, the PAL system remaining broken for 8 days is unreasonable. But members of the jury, don't let them tell you what is and isn't reasonable. They don't get to do that today. That's your job. Based on the facts and the evidence and the law as it will be presented to you by the judge, you get to decide whether or not Mr. Thompson acted reasonably. And you know what else you get to take into consideration in deciding whether or not he was working within those responsibilities set out by the FAA? Well, it's the responsibilities that were also set out for Zeke Fortenberry. He had responsibilities as a pilot as well regarding that fuel calculation, which you're going to hear a lot about today. Zeke Fortenberry couldn't just fill up that tank and go. He had to calculate exactly how much fuel it took to get from Kansas City to Dallas and have enough fuel left to fly around for 45 minutes. Sort of a safety net. But the evidence shows that he didn't make it to Dallas, that his plane ran out of fuel and lost power near South Fork, showing you those calculations couldn't have been made, or they couldn't have been made correctly. That from the moment that plane took off in Kansas City, it was not complying with the rules of the FAA. And again, don't just take my word for it. Don't just believe what's said to you. You get to see it. You get to see evidence and facts that support this. And Miss Kim Bates, she's a professional in aviation and accident reconstruction. She's going to take that stand today. She's going to review that important calculation with you and show you where factors were missed. Go over with you how important it is to understand the plane you're flying, how much fuel it burns per hour, the winds. You'll learn how important those are. Wind speed, wind direction. It all affects that calculation. And at the end of the day, the evidence and testimony will show that nothing Thomas Thompson did or didn't do, members of the jury, nothing Thomas Thompson did or didn't do can change what happened, or would have changed what happened. Zeke Fortenberry sealed his own fate when he sealed that gas cap in Kansas City. Find Thomas Thompson not liable.